Good afternoon, ladies and gentlemen, and welcome to this afternoon's webinar on preparing for the European Union's General Data Protection Regulation. I'm Alan Calder, I'm your host and speaker for this afternoon, and I'd like to start off by apologizing for the calendar, I guess you'd call it the calendar interface mismatch or something like that gave rise to the need to delay you all coming into the webinar this afternoon. I'm hoping that to make up for it, I'll be able to give you an hour's worth of as many insights into GDPR and what you need to do to have a chance of being compliant with it by May next year. The hour that we have for the webinar, about 45 minutes or so, will be me speaking to you, working through a series of slides which cover off the key areas that you need to begin thinking about in tackling GDPR, and then I'll deal with as many questions as I can. Please, as we go through the webinar, do use the question heading, the question box in the GoToWebinar panel on your screen. Type any questions you've got into that as we're going through the webinar, and then when we get to the Q&A at the end, I will simply start looking at the questions. I'll pick out the question at the beginning. I'll read the question out so everybody knows what the question was, and then I'll answer it. The first question most people will ask is, are the slides and the recording available? They will be available. They'll be going out over the course of the next couple of days to all the folk who are registered on this webinar. So we're going to be talking today, as we know, about the GDPR. My own background is in data protection. I've been involved in this area since the late 1990s, when a business I was leading was the first company certified to what is now ISO 27001, the international standard for information security. The book I wrote about how to do that has now gone on to its 6th edition. It's the postgraduate information security textbook at the Open University, and the publishing business which came into existence to deal with other books that I was writing has grown into an international niche publisher and has led to the growth and development of IT governance as a business, which really is now the leading one-stop shop for everything to do with governance, risk management and compliance. We deliver through a range of consultancy, training, both in-house and formal classroom training, staff awareness training, distance learning, books, tools, documentation, template toolkits, increasingly software as well, and we can put together any package of products and services that as an organization you need to tackle the most pressing GRC issues of your day, whether it's cyber resilience, GDPR compliance, information security. We can help you deal with that. And today I'm going to be looking specifically at the areas to think about in relation to the General Data Protection Regulation. So an overview of the landscape, looking at the principles briefly, and then the things that get you into trouble: breach notification, data subject rights, what the changes are to the law around consent, liabilities on controllers and processors, both clearly defined in the legislation, the role of a data protection officer. We'll briefly look at international transfers, which are important to everybody inside the European Union, and with the Brexit intention will be important to everybody inside Britain, as well as data transfers between the European Union and Britain will be subject to the same regime, and then a brief look at how the objective of achieving consistency in application of the regulation is achieved across the whole of the European Union. The starting point is the nature of European law, and it's worthwhile understanding that the two key types of legislation that emanate from Europe are in the form of directives and regulations. Directives tell member state governments what they need to do, and it's then up to member state governments to bring into force relevant legislation, which must meet at least the minimum requirements set out in the directive, but can deal with the matter in whatever way the member state sees fit. The existing data protection directive that gave rise to the Data Protection Act in the UK and other forms of data protection legislation in the other member states is exactly that. It's a directive. A regulation, on the other hand, is something which goes into force as passed by the European Commission. It's negotiated and agreed by member state governments, and as written is what goes into law. And it doesn't rely on enabling legislation. It doesn't require additional legislation from member state governments. At the point when it's due to become law, it becomes law. And as the name suggests, the General Data Protection Regulation is a regulation. So it comes into force as written unless there are specific derogations or options for member states to do something different already written into the law. And there are where the regulation is concerned. The model of data protection under GDPR looks a bit like this. It starts with the idea that a data subject that in normal terms is you and me. We're people, we have data, we own our data, we're living individuals. If we give our data to a data controller, an organization is a data controller if it defines what data to collect and the purpose for collecting it, then the data controller has got duties to protect the data, duties to reflect the rights which we as data subjects have. And those duties pass on to the data processor. A data processor is a third party processing data on our behalf, defined in law for the first time. And there are also requirements around the passing of data outside the European Union to third countries. GDPR recognizes that not all data will be gathered from data subjects themselves, and so there are sections which deal with the collection of data from third parties and the sharing of data with third parties. All of that supervised in the United Kingdom by the Information Commissioner, who is the UK version of the member state supervisory authority, and supervisory authorities have got powers both of assessment and enforcement in relation to GDPR. We'll look a bit at how that pans out, what that means, but certainly what they're going to be assessing is security with which data is processed, security with which transactions involve data are concerned, how security of personal data is guaranteed when it goes to third parties, dealing with issues around data disclosure, and all of that subject to the oversight of the European Data Protection Board. The EDPB is not a super regulator, it's a consistency mechanism. Its role is to make sure that supervisory authorities in member states interpret and apply the regulation consistently. One of the big drivers for GDPR is that there should be a level playing field, that all organizations operating across the European Union should know exactly where they stand and what they do. The rules should be the same, particularly if they're operating across border inside the European Union. And on the other hand, it recognizes that the rights of data subjects should be the same, irrespective of where in the union a data subject happens to live, or irrespective of with whom they happen to do business. And the EDPB exists to try and make sure that those key areas of consistency are protected in the implementation and maintenance of the regulation. So let's get stuck into the regulation. Articles 1 to 3 determine who it applies to and what's called the territorial scope, material and territorial scope. It applies to natural persons. A company is a legal person. It doesn't cover legal persons. It covers all natural persons and the information by which a natural person may be identified. And that means it includes business email addresses, business identifiers, online identifiers, anything that enables a person to be identified falls within the scope of GDPR. GDPR says that natural persons have rights in relation to the protection of their personal data, to the restrictions in relation to how it's processed, but also to unrestricted movement of their data within the European Union. And in pursuit of those rights, it says that any personal data that's to be processed wholly or partly by automated means, that means by a computer, or that's going to be in a filing system, whether it's a paper filing system or Outlook or anything more complex, is captured by the regulation. It's within material scope. Territorial scope applies to any controller or processor based in the European Union, irrespective of where in the world the data subject happens to reside or what their nationality is. And it also applies to controllers and processors based outside the European Union, but who are providing services into the European Union. You can see how at the point where Brexit becomes effective, it would apply to any organizations in the UK providing services into the European Union, would all be caught by GDPR. Why does it matter? Well, it matters first of all because natural persons, us, we have rights. We have rights wherever we think our rights have been infringed. We have a right to a judicial remedy, to go to court, to have the judge issue instructions to whoever's transgressed our rights, and to get financial compensation for material or non-material damages. We can pursue a controller, we can pursue a processor, and as I said, you can get financial compensation. There's no ceiling to the financial compensation that you can get. So that means that if an organization suffers a data breach, you can be sure that there'll be a number of data subjects whose data is exposed, who will see that they have suffered either financial or non-financial damage. Non-financial damage is they got very upset, and they will be able to bring individual actions against you, and you can bet there will be lawyers who will be there prepared to support them. That's probably a bigger challenge, although it's not getting as much in the way of headline coverage. The real headline coverage is the administrative fines that can be levied on organizations, and the key words here is that fines have to be effective, proportionate, and dissuasive. Dissuasive kind of means they're meant to hurt. And the two levels of fines are up to 10 million euros or 2% of last year's turnover, whichever is the higher, for a lower set of transgressions, or for the more serious transgressions which deal with failure to meet the data protection principles, failure to protect the rights of data subjects, and failures around transport or data flow. The administrative fines can be up to 4% of global turnover or 20 million euros, whichever is the higher. The information commissioners, supervisory authorities are required to take into account the extent of negligence or the extent of efforts made by an organization to comply with the requirements, and that's a good clue that even if when you breached you're not perfectly compliant, the fact that you've made your best efforts to get there will be taken into account and will have or should have the benefit of reducing the impact of any fines. Bear in mind that fines are in addition to, alongside, and parallel to any findings that are made in respect of data subjects who bring actions against you. So two key areas that drive organizations to recognize that you have to do something about it. And recognizing you have to do something about it also shifts, because you can no longer hope that no one will find out that you've had a data breach. GDPR requires any data breaches to be notified to the supervisory authority unless you can determine that there has been no risk to the rights and freedoms of natural persons. The definition of a personal breach under GDPR is very, very broad. It's basically any disruption, interruption, compromise of the confidentiality, integrity, or availability of personal data. Accidental, deliberate, the fact that data is not available when it needs to be made available. So if you think about a hospital which is attacked by ransomware, as a result of which operations have to be cancelled because personal data can't be accessed, that's a data breach under GDPR. Data processors, third parties who process data on behalf of controllers, have a duty to notify the controller of a breach as soon as they become aware of it. There's no exemptions, doesn't matter if it's a small breach or a big breach, you have to tell the controller. Controllers, on the other hand, have got up to 72 hours from when they first become aware to notify the supervisory authority, and they do have the possibility that if they can identify that there is no risk to the rights and freedoms of data subjects, they don't need to notify. But that's a process that you'll need to be able to go through. You'll need to have clearly defined criteria and a method of dealing with that. Now, bear in mind that most data breaches take place on Fridays. The reason for that is that most IT and security teams are not there over the weekend, and criminals like to have as much time as they can to do what they're doing. Your 72 hours starts at the breach. It's calendar hours, not business hours. So you've got to report by some time on Monday that you've had a breach, and you've got to be able to explain what the breach was, what you've done about it, how you're dealing with it, what the impact will be, and you're not going to be able to do that, frankly, without having a clearly defined, pre-tested, properly operating incident reporting and data breach reporting process. So one of the many areas on your what do I need to do list is going to be the development of an effective and robust incident report and data breach reporting process. And there isn't long for us to get ourselves compliant. GDPR comes into force on the 25th of May 2018. It will apply across the European Union. It applies irrespective of Brexit. That's always been the case because it's a matter of European Union law. Brexit doesn't change that. The Great Repeal Bill, which is being put forward or is being spoken about as coming forward to Parliament, will actually just take European Union law and put it into UK law. So Brexit becomes law. It goes on being law beyond Brexit. There might be some changes that the UK government makes at some later point in the future. You can't rely on any of that. What you can rely on is that if we're going to be providing services into the European Union, we're going to need to convince the European Union that our data protection legislation meets the EU's adequacy standard, of which more shortly. So, we talked about the rights of data subjects. The rights of data subjects are to consent to the processing of their data and to do that at a granular level. There are grounds under which consent is not required, and under those circumstances they have the right to know what you're doing and to access the information, to be told by law that you've got their data and you're doing something with it. They have a right to find out what you're doing with it, to find out if what you're doing is in line with what you've told them. If you've got their data wrong, they've got a right to rectify it. They can restrict the processing while they're arguing with you over the accuracy or otherwise of the data. They can, under certain circumstances, have their data erased when there's no longer a proper purpose for it to be kept. And they've got the right to data portability, the right to get their data back from you in a machine-readable format so they can take it to a competitor or to an alternative supplier of services. They've of course got the right, if they've consented to the processing, to be able to withdraw consent at any time. They can lodge complaints and they are entitled to know if you're doing automated processing and in particular what consequences might come from any automated decision making. Particularly important that for all big data applications include things like consumer loyalty cards. Those are all collecting information and there are automated decisions made as a result of that. Data subjects have a right to know what those are. And those rights are reflected in a set of data protection principles. They're similar, 6 of them. There were 8 in the Data Protection Act, but 2 of the old principles of the DPA have become separate chapters in the GDPR, so we're down to 6 principles, but the 6 principles have been made much more explicit and much more comprehensive. So the first principle is that data must be processed lawfully, fairly, and in a transparent manner. Each of those 3 words there is a test for, but the starting point really is the second principle, which is that data must be collected for specified explicit and legitimate purposes. It's the data controller who specifies what the purposes are, must be explicit about them. So saying I want to collect your data for uses I might have with it later or it might come in handy, that's not explicit. And the purposes must be legitimate in law, and legitimate again is a specific set of tests. And frankly, if you can, for any set of data that you're collecting, identify how you meet those requirements, it will be relatively easy to determine what data is adequate, how to keep it accurate, what the retention period should be, and how to process it lawfully, fairly, and transparently. In every case, you have to maintain security, and what's in effect, the 7th principle is into play with GDPR, which is that the organization itself is accountable for ensuring the data protection principles are in place and effective. And accountability means embedded inside the organization. In fact, the Information Commissioner, in a speech to the Chartered Accountants of England and Wales back in January, said the new legislation creates an onus on companies to understand the risks they create for other individuals and to mitigate those risks without thinking of it as a box-ticking exercise. It's about building a culture of privacy that pervades an entire organization. Put in place comprehensive but proportionate governance measures, make sure that accountability is part of the company's overall approach to how it processes and manages personal data. So that's a significant test, and it means that in any investigation following a data breach, you can assume that the Information Commissioner will be looking to see the extent to which accountability has become part of what the organization does, not just the extent to which box can be ticked. And accountability means you need to be thinking about data protection from the board down. You need to have an accountable director. Think of it much like you address health and safety. An accountable director, clearly determined roles and responsibilities should be on the board agenda on a regular basis, discussed by a board that understands what the issues are, should be included in the corporate risk register, clear roles and responsibilities through the organization for data protection. Even if there isn't a mandatory requirement for a data protection officer, it may well be a good practice thing for you to be doing. Certainly, given the complexities of compliance, it's probably a smart move to put someone into the role of data protection officer. You need to create a privacy compliance framework, and a privacy compliance framework is the combination of a personal information management system and an information security management system, which bolted together, reflecting the accountability framework, ensures that the board can give itself and its key stakeholders assurance that it's meeting the requirements of GDPR. The privacy compliance framework will encompass required records of processing. In parenthesis, there will not be under GDPR anywhere a requirement to register with the Information Commissioner, but there is a requirement to maintain very comprehensive records of processing for any companies over 250 employees. Smaller companies, there's a derogation which says that if there's no risk to rights and freedoms of data subjects, you can have much less in the way of paperwork. You need a cyber incident response process, a data breach reporting process. You need to think about security protocols and standards that you can use to give yourself assurance that security is appropriate. Cyber Essentials is one such. ISO 27001 is another. However you're addressing it, what the standard is looking for is something which you'll come across more and more over the next years, and that's data protection by design and by default. Building data protection into the way you design every single process, automation, every bit of collection of data, and the default position of the organization should be that it will comply with the 6 data protection principles in every aspect of its collection or processing of data. Which is fine going forward, but GDPR bites on the 25th of May, and at that point you need to be in compliant. You can't start your compliance journey on the 25th of May. You've got to already be there. We're 10 months remaining of a 2-year transition period which started in May 2016. So that means you need to go and look at your current data flows, do a data flow audit, do an inventory of databases, see how data moves between them, work out whether you are complying with the 6 data protection principles. On your key processes, look at doing a data protection impact assessment. It's mandatory for particular types of data flow or particular organizations. It's a good practice for all areas where you're collecting reasonably high volumes or reasonably sensitive data. So data flow audits, data protection impact assessments, the mechanical starting points for data protection by design and by default. I touched on consent earlier. The requirement under GDPR is that you have to have a lawful basis for processing personal data. For many organizations, the default has tended to be consent in the past. That really shouldn't be the case in future. There are a number of other lawful bases available so that, for instance, you can comply with your statutory obligations, or so that you can comply with obligations of a contract you've entered into with a data subject. And the legal requirements around the other lawful basis and consent are different. The other lawful basis, generally, you have to tell the data subject what the lawful basis is and give them an opportunity to object to the processing. With consent, you have to get them to give positive consent, and that means they have to be able to withdraw consent at a granular basis. You can't put together 6 things like we need your name and address, your next of kin data, we need your payment details, we need to know your previous employers, and we need to know all of that in order for you to work for us. because that's insufficiently granular for a person to give consent fairly in relation to each of the elements of data. You need to break it down into each of the individual elements of data so that a data subject can understand the lawful basis for processing each, and there are probably different lawful bases for each. In fact, consent is unlikely to be an appropriate lawful basis for any processing of data in relation to employees, certainly during the employment relationship, because the relationship is not equal, and one of the requirements of consent is that consent must be freely given. So, I said we'll come back briefly to consent, but however you've collected the data subjects are entitled to find out what you're doing with it, and so they're entitled to make a data subject access request. You're not going to be entitled to charge them £10 or any money unless it's a very complicated request, in which case you can recover your costs from them, but the onus will be on you to explain and justify your costs. You've only got a month to respond, so you need to have in place, bearing in mind that there's no longer the block of you have to pay £10. People can simply phone up and say, please send me my data. That's a data subject access request. You need to have processes in place that will enable you to capture and respond to that. And they need to be able to collect that data from you as a controller. If you've outsourced processing to a processor, you have to be able to gather it from a processor as well. You own the relationship with the processor. GDPR says that processors, in fact, can only process data under a specific legal contract with a controller. It will be illegal for an organization to say, I'm a processor, but I don't have a contract with a controller, because processors by definition are only processors if they're processing under a contract with the controller. If somebody says, I'm a processor, I don't have a contract with a controller, they're in effect saying, I'm a controller, but I didn't realize that, and that means you're probably going to be in breach of a number of obligations that you have as a data controller. So getting really clear in relation to each of your processing activities, whether you're a controller or a processor, and in any relationship between two organizations, you could be both controller and processor in relation to different activities. Complex but critical. So controllers are responsible for ensuring processors comply with contractual terms. Processors must operate under the terms of that contract, and that in particular, as I said, means that where a data subject is exploring whether you're processing data as they agreed to it, that means you have to be able to recover it from the processor. Consent can't be passive. You can't say untick this box if you don't want it to happen. If you're looking for consent, it has to be positive, there has to be a positive action, and it has to be as easy for a subject to withdraw consent as it was for them to give it, as obvious, as straightforward, and the consequence of withdrawing consent has to be as immediate. For children under 16, they can't legally give consent to processing their data in an information age service. This doesn't cut across any other areas where they are legally allowed to give consent, but specifically for social media, for instance, that's an information age service. They can't legally consent to the processing of their data. A derogation allows member states to vary that anywhere between 13 and 16, and if you're providing services that may be interesting to minors, you'll need to put in place a mechanism for ensuring that if you're gathering consent, you're absolutely clear about, and you have evidence that you're clear about the age of the data subjects, and if the consent has to come from an adult, you need a mechanism for demonstrating this is an appropriate authorized adult. Sensitive categories of data or special categories of data, what used to be simply sensitive information, in other words, health information, gender, political opinions, trade union affiliation, now extended to include biometric and genetic information. It's called a special category of data. It's forbidden to process any special categories of data unless you have, firstly, what we call an Article 6 based lawful basis, in other words, consent or meeting a contract, the lawful basis of processing we looked at, plus an Article 9 lawful basis for processing a special category of data. And that is mostly going to be consent, explicit consent to the processing for a specific purpose of that personal data. There are a couple of other areas where you can process special categories of data on a non-consensual basis, such as to protect the vital interests of the data subject or pursuant to a legal case or in line with your statutory obligations. But otherwise, the test around sensitive or special categories of data is much, much tougher. all information is subject to the requirement that it must be protected against both accidental and deliberate loss, damage, non-availability, release. In all your dealings with data subjects, you now have to be transparent, and that means that privacy notices need to be easily available. They need to be on a website. They need to be clearly written in very clear English so that anybody can understand them, particularly if it's a consent notice for a minor. That needs to be very, very clear. Where data subject seeks information under their right of access, the information you give them, again, must be transparent, complete. You can't hide information from them. Yes, of course, you can redact and in fact have a duty not to provide information about other data subjects, but you nevertheless have to respond transparently. You can get data from third parties, so you can get data from list brokers, for instance, but whether it's from a list broker or you've collected it from Facebook or you've collected it from somebody giving you their business card, before you process that data, you need to tell the data subject what you need to do. There's a specific privacy notice they need to be sent, which includes clarity about how they can exercise their rights, identification of what their rights are, and then links to the bit of your website which enables them to exercise each of the rights that we've talked about, including, of course, the right to be forgotten. That takes us then slightly more detail into the issue of data protection by design and by default. I touched on the idea that data flow analysis and data protection impact assessments are your starting point for building data protection by design. You may find that the reality is that your GDPR program is not going to leave you enough time to do DPIAs across all of your processing, so you'll need to focus on high-risk processing and deal with those areas first, and then over time, working to a plan, of course, tackle all the other areas. The requirement in the law is that you do a data protection impact assessment when you're introducing new technologies or you're operating technologies or processes that are likely to result in a high risk to the rights and freedoms of data subjects. So do think about building privacy data protection into your processes retrospectively. As I've said, you need by the 25th of May to know what personal data you're holding, the lawful basis on which you're holding it. You need to be in a position to handle data subject access requests, because a data subject access request which is made on the 26th of May will be something which the data subject's entitled to see acted upon as GDPR requires, not as the Data Protection Act allowed. So significant steps to be done to build the data protection by design and default component of your privacy compliance framework. Even more importantly, you need to be taking steps to secure personal data. The sixth principle says personal data must be processed in a manner that will ensure that it's protected against any unauthorized or unlawful processing or against accidental loss, etc. Pseudonymization and encryption are ways of reducing the risk to the point where there isn't formally a risk to rights and freedoms, but whatever you do, you need to recognize that steps like penetration testing to make sure that your perimeters are secure, that internal audits against GDPR and against information security controls, all of those are going to become part of your day-to-day activity to ensure ongoing compliance with GDPR. I've talked about Cyber Essentials and ISO 27001. They are externally audited and certificated mechanisms which enable you to give both your board as well as your stakeholders and regulators assurance that data is being protected and, more importantly, that information security is being managed in a structured and sensible way. So as you see, the privacy compliance framework pulls together the documentation for managing personal information, all of those data protection impact assessments, all of the how do we process data, the data subject access requests, all of that pulls together your information security management system and puts that together in a way that ensures that your governance, risk management and compliance objectives are met within an accountability framework. Talked about the importance of a data protection officer. GDPR makes a provision for a data protection officer to be a mandatory position in a specific set of circumstances, and those circumstances, they're set out in Article 37 of GDPR are where the organization is processing substantial volumes of personal data or special categories of data, substantial volumes of special categories of data, or it's a public authority, or it's potentially processing data in large quantities of public data. Data protection officer is a protected position, can't be fired because you don't like his advice, reports directly to senior management. GDPR says this person must be appropriately qualified. Doesn't mean they have to be a lawyer, but they have to understand the data protection law, and they have to be consulted in respect of data processing activities by the organization. Outside of mandatory appointments, it'll be a good practice appointment. Tackling GDPR without someone who understands the law and can give good independent advice is going to be very dangerous indeed. You don't have to employ your own DPO. You can appoint, GDPR says, DPOs on a service basis, a contract basis. You can have a DPO to serve a group of companies, a number of public authorities. You can hire a DPO to come and provide a service on a hourly basis or on a number of days in a month basis. You need to extend GDPR training across the whole organization so that not just senior people but also those dealing with data, so marketing, HR, and all of those areas which will touch on the collection or processing of personal data, understand the regulation and what they need to do, understand how to recognize the impact of an accidental release of personal data, understand how to recognize a data subject access request. So staff awareness training, typically done online with some form of e-learning where you can give all staff exactly the same level of training. You can tie a test to it which can give you evidence that everybody has learned what you needed them to learn, is how most organizations are tackling the requirements around staff awareness. GDPR makes specific provision for organizations to turn to certifications to demonstrate compliance with the regulation. So you have to take appropriate administrative and organizational measures to secure personal data. You have to do that in the light of a risk assessment because appropriate isn't defined. You have to work it out for yourself. And a standard like ISO 27001, which meets GDPR's requirements for what an acceptable standard looks like, sets out how an organization would do an appropriate risk assessment, how it would select controls, how it would manage the controls in relation to those risks. BS 10012 is the British standard for a personal information management system. It may or may not become a European and international standard, but if it does, it could suddenly become very useful outside the European Union, outside the UK, as part of a privacy compliance framework. Privacy compliance framework, as I said, will also include external certifications like Cyber Essentials, which is a very low-level certification and a sensible starting point for organizations which haven't yet done anything formal to give themselves assurance that they're protecting themselves against cyber risk. The fact that you have a certification, ISO 27001, BS 10012, Cyber Essentials, all that does is demonstrate you've done your best to meet your obligations. It doesn't absolve you of compliance. There's no technical mechanism right now, there may never be, of guaranteeing or be certain of being in compliance with GDPR, because GDPR is a law, and that means decisions over the next 10 to 20 years about what individual words and phrases mean will be subject to legal decisions and decisions in law courts and appeals and all of those kind of things. I talked about international transfers. GDPR, rather like the Data Protection Act, says data can't be moved outside of the European Union unless it's appropriately protected. And appropriately protected means that it's going to a country for which there is already a finding of adequacy, and that's all the European Economic Area countries. It's Canada, it's the Channel Islands, it's a couple of New Zealand, a couple of Switzerland, a couple of other countries. So transfers on the basis of adequacy, transfers on the basis of standard contract clauses, or transfers on the basis of binding corporate rules are the three ways in which legitimately an organization can transfer data. In terms of the US, there is no finding of adequacy, nor is there ever likely to be unless something significant happens in the way the US approaches federal level data protection regulation. And the EU-US Privacy Shield is the current mechanism for providing the equivalent of an adequacy test for those organizations who register under it to process the data of providing services into the European Union. Beyond Brexit, there is currently no formal plan for an EU-UK privacy shield, so one has to assume that the UK after Brexit will be in the same position as India or Venezuela or Peru is in terms of the processing of personal data. Particular challenge, therefore, for any services that you're using in the cloud. Cloud processors don't necessarily host their information inside the European Union. You'll want to make sure that any cloud processing or hosting or activities you're doing, you have control over where the data is hosted. And if you don't, you're laying yourself open to the higher level of fines. The high level of fines, if you remember, are around breaches of data protection principles, breaches of the rights of data subjects, and breaches of the trans-border flow provisions. And those fines come from independent supervisory authorities. Member states have to put them in place, have to give them adequate budgets to carry out their responsibilities, and they have to be independent. They have powers to enforce, to guide, to communicate, and to levy fines. Because the GDPR is supposed to be the same across the European Union, companies operating in multiple states can choose a single supervisory authority to be their lead supervisory authority for all of their pan-European activity, which can simplify your compliance activity substantially. The EDPB, as I said at the beginning, it exists to make sure that those independent supervisory authorities don't get too independent, that they interpret the regulation in a consistent way, that the way in which the regulation is applied is done the same right the way across the European Union, so that it's a level playing field for organizations and also a level playing field for EU subjects. The Information Commissioner's final words were, if you can't see the commercial advantage, the competitive benefit in getting to grips with GDPR and putting in place a culture of privacy by design, if you can't see that that's going to help you win customers, remove complexity from your processing, help you get rid of data you probably shouldn't be holding, if you can't see all of that, then you just have to recognize that you're likely to be fined, because we also have a very big stick and we are very happy to be using it. And bear in mind that if we're using it, it won't be because of based on a minor breach. It will be because when we investigate, we find that you haven't taken on board the principle of accountability. It's not embedded in your organization, and that's what we'll be addressing. So what do? We identify 9 steps to GDPR compliance. If you go on our GDPR practitioner training course, you'll begin to find how we address some of those. The first is to create a governance framework. That means board awareness, risk register, a proper accountability framework, and then work out who's going to take on the data protection officer role. Is it mandatory? Is it simply a good practice appointment? Identify what data you've got. Who are your processors? Work out the lawful basis for holding the data. Do a data flow audit. See what happens to the data as you gather it, how it moves. Are you protecting it through that process? Do you have appropriate privacy notices in place? Are your subject access request processes robust and legal? Do you have processes describing your processing, records of processing? Do an analysis of your information security activities. Where necessary, do a data protection impact assessment, and all of this will flush out areas that you need to tackle. Remediate. Put in place a functioning privacy compliance framework. In parallel, get started with your information security activity if you haven't already got that in place. Make sure your information security activity and your data protection, your privacy management system stuff all comes together. And then start monitoring how effective that works. Don't start monitoring come May next year, start now. Start looking at how you can drive improvement through what the organization is doing. Bear in mind that in probably 95% of GDPR requirements, you don't have to wait until next year, because if you were doing most of those things now, you would still be in compliance with the Data Protection Act. And that really means you should get started now. I know that in the UK, many organizations are nowhere near as advanced in their DPA compliance as perhaps they should be, and that means the gap that has to be made up is very substantial. GDPR is designed to build on the Data Protection Directive. It's designed on the basis that organizations will have been obeying the law up till now. And so if your DPA compliance is somewhat deficit, then your GDPR compliance is even more deficit, and you need to get a program put together and you need to get moving, heading towards compliance as quickly as you can. I recognize that you may not be fully compliant by May next year, but if you can demonstrate, frankly, that as soon as you understood what you needed to do, you took all of the appropriate steps that you could, you committed the right resources to the project, you've got on with it, and yes, you're not fully compliant yet, but you can point at a plan which you're in progress of implementing, the plan is working, you're making the right sort of progress, we would imagine, and bear in mind that we're looking into the future here, it's not a very reliable thing to be doing. We would imagine that that should be something which you will be able to say to the Information Commissioner is evidence that you've not been negligent, and they are required to take not negligence into account. Ladies and gentlemen, that's roughly where I was intending to stop what I was talking about. I'm just briefly, before we go into questions, going to tell you that there's a bunch of stuff available that you can use to help your GDPR compliance program. There's a pocket guide, a very short introduction to the GDPR, there's an implementation manual, there's a new version of that coming out very soon. The documentation toolkit we've just updated to reflect what we've learned about GDPR. You know, we're still learning about what this all means. We've been at it now for a year. Documentation toolkit will give you all of the documents you're likely to need in a template form that you can easily adapt. A gap assessment tool which somebody who knows what they're doing can use very quickly to work out what you need to do to get compliance. And knowing what you're doing is important. A foundation training course will introduce you to the basic concepts of GDPR. The accredited practitioner course will give you what you need to do to implement it, to be a data protection officer, to deal with the breadth of maintaining GDPR compliance. And both of those courses are available in public classrooms in the many cities in the UK and increasingly across the European Union. They're available in distance learning format, and they can be delivered in-house where you've got a number of people who need to be trained. There's a data protection impact assessment workshop. That's not a certification course. The other two are. They produce internationally recognized and accredited certificates of competence. There's also a thoroughgoing range of consultancy services available from a range of experienced consultants who either have legal or information security or a combination of backgrounds, who can carry out a gap analysis for you, identify what you need to do, help you as you need to address GDPR compliance, provide anything from project management through to particular implementation expertise, do data flow audits, help you tie into ISO 27001. And as a company, as you saw earlier, we can help you across the broad range of your challenges, whether it's cyber essentials or penetration testing or any of the other things which become fundamental to GDPR. And before I go into questions, the last thing I want to say is that the UK government has decided that rather than regulating, passing law to force companies to put a cybersecurity regime in place, instead of that, it's going to put effort into enforcing the GDPR, because it sees GDPR as being an already existing, very thorough and competent mechanism for driving organizations to put appropriate methods in place, mechanisms in place to protect personal data. So this is going to get, on that basis, very substantial government focus, in spite of the likelihood that they're going to be increasingly drawn into trying to deal with the complexities of this Brexit strategy, which some of them are so keen on. Ladies and gentlemen, let me stop right there. I'm going to turn to questions. Those of you who've still got questions but haven't asked them, there is a question and answer or question session in the in the GoToWebinar panel. Please do type your questions into there. I'm going to pick up the questions. There are quite a lot here. I probably won't have a chance to get through all of them today, and therefore we will try and pick up the rest of them and feed them out later on this week. Sorry, it'll be later on next week, so that you will see the answers. But let me start with the first question, which is GDPR applicable to B2B industries? Yes, GDPR applies to all personal data irrespective of the context in which it's collected. So a business email address, alancaulder@itgovernance.co.uk, that's personal data, it identifies me, and therefore you have to do in respect to that piece of personal data exactly the same as you might do in respect of acaulder@googlemail.com. Neither of those email addresses, by the way, is correct. So yes, it's applicable to every organization that's collecting personal data that's going to be part of a filing system or is being processed in an automated way. A web-based system, next question, whose code and database is held in the EU can obviously be accessed by users and customers anywhere in the world. Would the controller need to obtain explicit consent from those users or customers from outside the EU? If so, how would such a consent question need to be worded? Partly you need to talk to your own legal advisors about that. The general answer to that question is that if you are a controller or processor in the European Union providing services to anybody in the world, whether in the EU or elsewhere, you have to have a lawful basis for processing that data. That lawful basis is not necessarily consent. It will depend on, the lawful basis will depend on the purposes of processing, and so in thinking through with your lawyers exactly what it is that you want to do with that data, you'll be able to determine what the lawful basis of processing is. If you go to a legal advisor who is familiar with GDPR, you're looking at Articles 5 through 7 in terms of lawful basis of processing. But yeah, you have to have a lawful basis of processing. You have to be transparent with the data subject about what you're doing, about how to exercise their rights. Can you please confirm that small local charities are bound by the GDPR requirements? I'm afraid I have to say that I see nothing which says that GDPR doesn't apply to certain size organizations or doesn't apply to certain sectors. There are derogations in GDPR which say that organizations with under 250 employees, and obviously a charity of this size will fall into that group, are able to avoid the requirements in relation to documentation if there is no risk to the rights and freedoms of data subjects. And again, that's something that we hope we will see advice from the Information Commissioner on. What does that actually mean? But in terms of being a controller, of collecting data, all of those obligations apply just as much to a very small charity as they do to the biggest organizations in the world. And as you will have seen, the Information Commissioner in the last months has made no bones about finding a range of charities whose data collection mechanisms fell outside the requirements of the current data protection regulation. Does GDPR affect public company level data captured through online means? Yes. Yes, you can capture data. If somebody publishes their personal information, you can capture that data, but you can't do anything with it without having first told the data subject. Article 14 of GDPR says any data gathered not from the data subject, you have to tell the data subject where you got it from, what you intend to do with it. You have to do that on first processing or certainly within 30 days. And you have to give them a clearly set out and transparent mechanism for objecting, i.e. opting out of what you're doing. You can't simply collect the data and do with it what you want to. Would the database key of a personal record be considered as being personally identifiable information? If that database key enables their information to be recognized, yes, it would. GDPR says any information that enables someone to be recognized is personal data. An online identifier is, an IP address is. They're all clearly defined as personal identification. If a company has a couple of subsidiaries internationally, would you need a data controller in the main office and a data processor in each subsidiary? So that's a good question on two levels. A data controller is not the person inside the organization, it's the organization. And it's the organization's role in relation to the processing of data. If the organization is in the EU and that organization is determining what's going to happen with the data, it's collecting it, it's going to be a data controller. If it's got subsidiaries outside the European Union to whom it's passing the data to do stuff with the data, then those organizations may very well be processors. All three of the organizations are bound by GDPR. If the two subsidiaries are outside an EEA country, you've got transport and data flow issues, and one way of dealing with those in a group of companies is binding corporate rules. And again, a conversation with your GDPR professional advisors should help you work out how to address that effectively. A privacy notice must be concise and clear, but it is also necessary to be specific, transparent, and granular on processing. What's the best practice on this? Explain all the reasons and processing, or keep it general? The answer is both, and that might seem contradictory, but the pressure from the European Working Group and the Information Commissioner is towards the idea, for instance, of using standard icons in privacy notices, which will mean that wherever that icon is used, it means a certain type of activity is taking place. And an organization can create, even if it's not using a common set of icons, could create a privacy notice which just has icons which link through to more detailed information on its website, which makes it easy for a data subject to navigate it. But I think that this is one of many areas where there will be legal arguments over years to come over whether a given provision, a given privacy notice met all of the requirements that are set out. Our job in the meantime is to try and do the best we can to stay out of trouble, and I would suggest that that means doing the best you can, and then when a data subject says I didn't understand, have a continual improvement process in place that means you go okay and you improve it and make it better for them. You stated that it would be illegal for a processor to process data without a valid contract with the controller. What constitutes a valid contract? Well, it has to be a legally binding contract written under European Union law, because the could be written outside if the controller is outside the European Union, but it has to be enforceable, so it has to meet all the standard legal requirements of what a valid contract looks like. It has to set out very specifically the obligations on the data processor around protecting the data of data subjects, around returning data to the controller at the end of the processing, about access to data and so on, all set out in GDPR. But the starting point is it's got to be a valid legal contract. Why and how are those independent supervisory authorities appointed? Member states get to appoint the supervisory authorities. In most cases they already exist. In most cases the existing data protection commissioner or information commissioner, as the case may be, will become or has become or is in the process of becoming the GDPR supervisory authority. So the starting point in any member state is go look and see who the current supervisory authority is, assume that they will become the GDPR supervisory authority. Data breaches, can we report within 72 hours and say we're not yet clear on the scope of the breach, we're looking into it? Yes, GDPR makes a provision that says you can report a breach and provide data in stages as you're getting it. You have to be really clear as to why you have to provide in stages, what the new stage will get. So providing in stages on the basis that you are inadequately prepared is not smart. Providing it in stages on the basis that it's a complex breach and it requires additional investigation, you're deploying your pre-trained and planned investigators, that should work perfectly well. For marketing, direct marketing, previously companies relied on consent. What's the justification under GDPR? How should that be dealt with if consent is not an option? Well, under GDPR, you have a legitimate interest in marketing and direct marketing to existing customers as long as it's closely linked to what they've purchased from you. You don't have a legitimate interest in selling them other things. You don't have a legitimate interest in sharing the data elsewhere. You'd have to have some other lawful basis of doing that. In most cases, that will be consent. And so you need to put in place a mechanism to get their consent, and if you don't get their consent, then you don't market to them. I understand that in many instances that may lead to you having fewer people to talk to, but you might also console yourself by saying, asking yourself whether you really want to be talking to people that didn't consent or don't want to be talked to. But it's a complex area, but GDPR again is really, really clear. There is no possibility of implied consent. You have to have consent, or you have to have some other lawful basis. When we introduce new policies, is there a preferred way in which to notify data subjects of the updated policy? The preferred way is one, frankly, which ensures they get it. There are lots of ways that have proven over the years not to work. Putting a policy in place, teaching people it proactively, and then auditing compliance is traditionally the most effective ways of making sure people get it. Say, here's a training session, we're telling you what to do, there'll be an audit that you're doing it right, that'll identify where you're not doing it right, there'll be improvement requirements. Putting it in place, driving it in, only way you can do it, normal reality. We still have some business that don't even have a domain in place, so store data on workgroup PCs. No, you're right, that will never ever be compliant. If lots of people can access personal data, remember GDPR is only dealing with personal data. If lots of people can access it, you're going to struggle to demonstrate that you've taken appropriate steps to protect the data on a business need to know basis. You could, on the other hand, arguably have lots of people access it, as long as when you say in your privacy notice you tell the data subjects, please consent to us putting this data into a work group where lots of people we don't know who can access it for purposes that we don't need. No, I'm just joking, that too would be illegal. Prince 2 would help with the process and project requirements. Yes, it would. It's a project management methodology. Implementing GDPR is a project. PMBOK, any existing project management methodology will help. GDPR definitely impacts the startup industry. It impacts how due diligence is carried out. It impacts how fundraising takes place. All of that is impacted by the fact that you're collecting and processing personal data. New companies will need to be GDPR compliant. They've got the derogation. Nobody's data is at risk apart from our employees, so compliance will maybe be not that hard. There's no official certification for GDPR compliance. There are official certifications for competence, the accredited GDPR Foundation and Practitioner courses, which you can access through the IT governance websites in the UK, US, European Union, are accredited certifications for individuals. But as I said, GDPR is a law, and I suspect there may never be a certificate of compliance to the law. There will be best practice certificates that say you're doing a good job, but none of those start yet. 72-hour clock starts from the date and time of the actual breach, or from the date and time at which the data controller becomes, it's from the point at which you become aware of the breach. Don't think of that as license to try and avoid becoming aware of it, because if the breach happens and it takes you 2 years to become aware of it, you can be sure that there will be some serious questions asked about the inadequacy of your incident reporting processes, and the damage done in future will be very much like the damage which has happened to Yahoo, just that in future it will happen much more quickly. As a processor who has hundreds of data controller clients, how do we go about so many legally binding contracts? It's a terrible challenge, I agree. You essentially have to create a contract, a template contract, and say to all of your controllers, we want you to instruct us to process the data in the following ways, because that's how we can deliver a service to you. It's possible that you might, and this is going to require a little bit of thought, you might be neither a controller nor a processor. Remember, a controller is an organization that determines what data is to be collected and what it's used for. If you're simply providing a platform on which the controller processes the information themselves, you're not necessarily a processor. You may be simply a platform, in the same way as Word is simply a piece of software. The fact that personal data is entered into Word doesn't suddenly make Word a processor. Software as a service isn't suddenly a processor because somebody's doing something with it. And you'll need to think through very carefully the definitions of controller or processor, and don't get yourself, if you're actually just a platform, don't get yourself bogged down in levels of compliance that may be unnecessary. We're kind of coming to the end of time. There's still a lot of questions left. I'm just going to pick up a last one or two, and then I'm afraid I'm going to have to draw it to a close. How taking credit card payments over the phone comes into GDPR, what companies should do to deal with this. So personal data, the definition of personal data includes payment card data. So if you have a breach and it turns out that you're also not PCI compliant, you'll get your head kicked in by the PCI DSS as well as by the Information Commissioner, because you must be PCI compliant contractually. And the ICO will probably levy a higher fine because it's negligent not to be PCI compliant. Under PCI, if you're processing a payment details over the telephone, you should by rights be processing that data directly into a secure terminal, and you should be processing it however you do it in line with the requirements of GDPR. And so in a sense, if you're meeting your PCI requirements around processing payment data, you'll be meeting your GDPR requirements as well. Finally, very good broad question. If you're collecting a business card, would you need to tell the person the information will be held on a CRM? Yes, it's personal data. What I would do is just collect the business cards, and at the point the data is being loaded onto the CRM, have an automated Article 14 privacy notice go out to the data subject saying, got your data, gave it onto us on a business card, this is what we're planning to do with it, this is how long we intend to hold it for, here are your rights, this is how you access it, because for all processing you're still obliged to tell the data subject how to exercise their rights. So apologies, it's been a very fast run through. There is another series, the extended series of webinars. We're repeating this on a monthly basis, so you can resit this webinar. It'll be coming out in pre-recorded format. There are webinars around specific aspects of GDPR. More usefully, there are our books, tools, our foundation and practitioner training course. So if you don't really have time and you just need to get started, call us or email us today, arrange to talk to an account manager about how we can give you a GDPR gap analysis and begin working out what your GDPR compliance project has to look like. Ladies and gentlemen, thank you all for joining us. Again, apologies for the rescheduling at the beginning, but I hope that I've made up for it in terms of giving you lots of insight into the challenges ahead. Good luck with your GDPR compliance program, and as you know, if there's any way we can help, you have but to call. Thank you and have a good evening.